Hi, today my friend Jeffrey and I will be presenting our conflict of laws video assignment on anti-suit injunctions, or we can call it ASI. I will begin with the development of ASI, and Jeffrey will follow with an in-depth analysis of how they are applied and the controversies surrounding them. So let's start with a simple scenario. Imagine you and your business partner sign a contract that clearly states any disputes will be settled in English courts. A year later, things go south, and instead of suing you in England, your partner takes the case to a foreign court, let's say Italy. Now you are stuck. Should you fight it there or risk a default judgment? That is where an ASI comes in. It is a special order you can ask from the English court, telling your partner, you agree to sue me here, not there. Stop what you are doing. It doesn't target the foreign court directly, it targets the person, but the effect is the same. That is the essence of an ASI, to prevent unfair or duplicate litigation and uphold the parties' agreed choice of forum. But within the EU, this tool becomes highly controversial, and that is what me and Jeffrey will talk about later. So the power to grant ASI originates from English equity. Courts use this power when the foreign proceedings were considered vexatious, oppressive, or simply unfair. Early cases like Love and Baker and British Airways confirmed that courts could issue ASI against a party if the action abroad were abusive. Even though the injunction is against the person and not the foreign court, it still affects the foreign proceedings. And that is why critics say the distinction is artificial and to me maybe delusional. So to me, if you prevent someone from participating in a foreign lawsuit, you are essentially interfering with that lawsuit, regardless of how you frame it. So moving on, a clear structure to the SI test wasn't really established until the case of Airbus Industrie and Patel. Lord Gough in that case said two main things. First, the English court must have a sufficient interest or connection to the dispute. Second, the ASI should only be granted to stop unconscionable conduct or to uphold a jurisdiction agreement. First, the test of vexation or oppressive conduct. In the case of SNIA and Lee Kwijat, the natural forum was England, but one party tried to sue in the US to take advantage of contingency fees. The court said this was a clearly tactical issue and issued an ASI. In another case of Simon Engineering and Buck Mining, a party filed proceedings in Texas. But Texas law would prevent the other side from relying on indemnities available in Brunei, which was the natural forum. Again, the court issued an ASI. Turner and Grovick case is another major one. The employee sued in the UK for wrongful dismissal. The employer retaliated by suing the employee in Spain. The court saw this as a financial pressure tactic and granted an ASI. All these cases show a common thread. If England is the more appropriate forum and the foreign litigation is abusive or duplicative, an ASI may be justified. Second, the test for upholding jurisdiction agreements. In the case of Donahue and Amcor, the parties had an English jurisdiction clause, but one party sued in the US. The court said that breaching the agreement justified an ASI. So Lord Justice Brooke in the Court of Appeal even suggested a kind of reciprocity rule. If someone sues in England in breach of a foreign jurisdiction agreement, England stays its proceeding. So vice versa, if someone sues abroad in breach of an English jurisdiction agreement, that foreign court should also stay its course. But since foreign courts don't always follow this, ASI become necessary to protect agreed foreign clauses. However, Lord House in the House of Lords was more cautious. He said that ASI should only be granted for just jurisdiction clauses if there are strong reasons, especially if England isn't the natural forum. Later, in Turner and Grovick, Lord Hobhouse went further and said ASI should only be used to protect existing English proceedings. If there is no active case in England, the justification for ASI becomes much weaker. Now we move to the concept of committee, which underpins much of court's hesitation in issuing ASIs. In the case of Airbus, Lord Gough cited the US definition from Houghton and Guyot, which define committee as a recognition one nation gives to another's laws and judicial acts. A committee is a very loose concept. In some cases, like SNIA, it is interpreted as a spirit of cooperation. In others, like the case of some port tax and Philadelphia, it is just about convenience. So to me, this shows how fragile the foundation of committee really is. It is inconsistent, and courts are being asked to make serious decisions about foreign legal systems based on a doctrine that is vague and unsettled. That is why many scholars and judges have called ASI dangerous. They ask domestic courts to interfere in foreign legal processes while relying on an uncertain principle of mutual respect. So to summarize my part, SI started as equitable remedies to stop unfair or abusive litigation. Over time, courts narrowed their use to two main grounds: vexation oppression and jurisdiction agreements. There are key cases like Airbus, SNIA, Turner, and Donahue to show these evolutions. And while committee tries to guide restraint, it is a weak doctrinal anchor. So next, my teammate Jeffrey will explore how the EU approached ASI and how CJEU rulings like Turner and Grovit, Gasser, and West Tankers shut the door on ASI within the EU and what that means post-Brexit. Thank you.
I'm Jeffrey, and now let's move on into the second part of our presentation. So for my turn, I will be focusing on the analysis of anti-suit injunction, ASIs, especially within the European Union, and the role of CJEU. So the core conflicts, ASI versus Brussels regimes. To understand why ASI are so problematic in the EU context, we need to first understand the goals of the Brussels regimes. So whether it is the original Brussels Convention, Brussels, or the recast regulation, the aim has always been to ensure consistency in jurisdiction rules across member states. It rests on three key principles: mutual trust, legal certainty, and the smooth flows of judgment across borders. So now, here's the problem. ASI allow one court to stop proceedings in another's jurisdiction. So that clashes directly with the principles of mutual trust. The EU legal systems assume that all member states' courts are equally competent and trustworthy. So if an English court issue an ASI to stop proceedings in, say, France or Spain, it is essentially saying that we don't trust that courts to decide fairly. That's exactly what the Brussels systems doesn't want. So now, the game changer. Let's talk about the case of Turner and Grovit. In this case, an English employee was suing his employer for unfair dismissal. Then the employer suddenly sued the employee in Spain. The English court issued an ASI to stop the Spanish case. But when it reached to European Court of Justice, the decision was clear. ASIs are not compatible with the Brussels Conventions. The court didn't buy the arguments that ASI only act in personam. They say that the real-world effect is that the foreign court jurisdiction is being blocked. And that's the key takeaway from the Turner case. Mutual trust means letting foreign courts, even if they might be misused, decide on their own jurisdiction. So another case is the Gaza and Mizat. So this is the case known as the Italian torpedo. And in this case, even when parties had agreed to litigate in Austria, one party is preemptively sued in Italy, which is known for slow proceedings. And that tactic is famously referred to as the Italian torpedo. So now, you think, surely the Austrian courts can jump ahead because it is in a contract, right? So, but no, under Article 27 of the Brussels, the court first sees tax priority. The ECJ confirms that rules must be strictly followed. So again, an ASI to stop the Italian case will not be allowed. even though the case clearly undermines the agreed jurisdiction clause. So another case is the West Tangle case. Arbitration isn't safe. Either you might think arbitration is safe from the EU ban, because the Brussels regime says arbitration is excluded. But West Tangle changes that, and in this case, the dispute was supposed to be resolved by arbitration in London. Still, a party sued in Italy. The English court issued an ASI, but again, the ECJ struck it down. They say that even if arbitration is excluded, the court proceedings in Italy still falls within Brussels, and the ASI interferes with that court jurisdiction. So even arbitration clauses didn't escape the ECJ stance. This was particularly controversial because it clashes with the New York Convention and even commercial reality. So this decision has sparked widespread criticisms. Among them, we have the John Harris point out that the ECJ black and white approach doesn't let national courts deal with the real world abuse. So for example, what if tactic? English court can't stop it anymore. He suggests that a balanced case by case test like oppression of accessions would work better. Another person is the Claire Ambrose, also says that ECJ is prioritizing structure over justice. Sometimes the ASI is the only remedy against procedural abuse. And we have the famous Thomas Raphael, it that the ECJ refusals to allow any flexibilities undercuts the effectiveness of jurisdiction clauses entirely. So these criticisms shows that while the EU legal system's value order, it sometimes sacrifices fairness along the way. So now, is there any improvement? Now let's see if things change with the Brussels recast regulation. So in Article 31st, Clause 2, it was introduced specifically to counter the Italian torpedo tactic. It says that if you have an exclusive jurisdiction clause, the chosen court doesn't have to wait. It can go ahead even if it is not the first court seized. So this is a big improvement, but here's the catch. Article 31st Clause 2 doesn't bring back ASIs. It just gives rooms for maneuver. This overall ban on ASIs under Turner and West Tangle still stands. So while recast helped a little bit, it didn't solve the deeper problem. So at its core, this is a clash between two legal worldviews. The common law emphasis on protecting contractual expectations and preventing procedural abuse, and the EU system-first approach which places legal uniformity and institutional trust above all else. Yes, there are criticisms, but despite the criticisms, we must confront the deeper systemic threats that ASI posed. In contrast to the common law emphasis on fairness through judicial discretions, the EU legal framework is built on mutual trust, procedural discipline, and jurisdictional balance. So permitting ASI within a context will not just be a technical anomaly, it would be legally destabilizing. Allowing anti-suit injunctions undermine the very foundations of the Brussels regimes, which rest on mutual respect for each member state's judiciary. In West Tangle, the CJEU warned that allowing national courts to preempt each other through ASI creates de facto exclusive jurisdictions. One court, by issuing an ASI, effectively neutralizes the authority of another. This is not just cooperation, it is a power cloaked in procedural justice. And make no mistake, the consequences are not theoretical, as I invite retaliatory counter-injunction. Escalating jurisdictional tough wars, they fragment legal unity, fuel strategic litigations, and burden litigants with layers of legal uncertainty. So far from promoting fairness, ASIs reintroduce the exact kind of forum shopping and procedural manipulation that the Brussels regimes was designed to eliminate. So even post-Brexit, when UK courts revived the use of ASIs, European courts have consistently refused to recognize or enforce them, citing public policy concerns. So the message is clear. There is no room for unilateralisms in a multilateral system. Article 31st, Clause 2 of the recast regulations provides a structured response to torpedoes tactics, allowing the contractually chosen courts to proceed, but it does so within the rules without judicial overreach. So while the common law traditions mourns the loss of a flexible remedy, the CJEU ban is not only justified, it is essential. ASI are unpredictable, interventionist, and doctrinally unstable. Their elasticity invites abuse, and their operation threatens the very coherence of cross-border litigation within the EU. So, in conclusion, the ban on ASI is not a flaw. It is a feature of the Brussels regimes. It affirms the EU commitment to collective order over national control, to legal certainty over discretionary interference. For a legal system that aspires to be uniform, fair, and cooperative, the ASI is not just outdated, it is incompatible. Thank you.